following the file. That is the most
the salient features, because it will still be uploaded. Yes. No, those would be.
Yes.
If you have got a hard copy, you can quickly go through the salient features. You need not go through everything.
Yes.
It's entirely.
My Lord, what the state wishes to say is that the applicants applied for bail before the lower court, and they were denied bail for the following reasons. The record is...
wait, Mr. Mabodi, there's something coming up here. Issued on the 8th. What's the date today?
The 8th.
Something approved at 17 past 2 today.
Yes, it could be.
So we have it. Let's see. Is it any different from the first document that you found?
Largely, it is the same, but there are some additions that the state is making in view of what is
transpired
from the application.
Okay, wait a second. Is this what you signed on the 8th of January?
Yes.
Yeah, I've got that. Yeah, so you can go through that. I suppose if all of us are online, we will be able to find that document.
Now, on the second page of my response, I highlighted that at the end of the application in the magistrate court,
on the second page.
At the end of the application in the lower court, both applicants were denied bail by the magistrate court for the following compelling reasons, according to the record which is before the court in terms of section 170, large A, subsection 7. Firstly, they were denied bail for the reason that there was a likelihood of the two interfering with evidence, investigations, and state witnesses. Secondly, they were denied bail for the reason that they were likely to abscond. Thirdly, they were denied bail because their admission to bail was going to undermine public order. Fourthly, they were denied bail for the reason that there was a likelihood of public outcry. Fifthly, they were denied bail for the reason that there was a likelihood of undermining of peace, security, and order. And sixthly, they were denied the reason, bail for the reason that the admission to bail would jeopardize the proper administration of justice, including the bail system. It was further held by the lower court that that title deeds offered by the second applicant was just a piece of paper without physical verification on the ground. B, that the applicant's residence remained disputed regard being had to the issue of uncompleted building referred to by the state in respect of the first applicant, and false address where a certain white man, Mr. Brown, was staying in respect of the second applicant. There was a manhunt after the accused persons had failed to appear at the ZAC offices. Mr. Mgia, for the second applicant, told ZAC at the time that the applicants were hostile and hence they could not be secured. D, the applicants were not coming from home but from ZAC offices. This was what was held in the lower court when they were denied bail. If one goes through the record of proceedings and the judgment of the lower court, these are the reasons why they were denied bail.
Yes.
Now, it is submitted that the judgment of the lower court where the above findings were made remain extant in the sense that there was never any successful appeal against it by a superior court. Through their lawyers, the applicants strongly argued that the judgment by the lower court is irrelevant, not applicable, and doesn't bind this honorable court. It is submitted that the denial of the lower court to grant the applicants bail gave rise to the automatic effects of Section 66, subsection 2 of the Criminal Procedure and Evidence Act, Chapter 9.07. This section has the effect that a warrant for further detention issued by the magistrate on indicting the applicants meant that they were to remain in custody until their appearance before the trial judge. Thus, the denial of bail gave rise to the warrant for further detention, and the compelling reasons remain operative. There is no lacuna in our law. In the case of State versus Mpofu and another, I got Harare 409 of 24. The Honorable Kwenda J on page 2, paragraph 2 of his cyclo-style judgment eloquently stated the following on the effect of a warrant for further detention issued by the magistrate in pursuance to the provisions of Section 66, subsection 2 of the CP&E Act. And I quote, "As required by law, upon indictment of the applicant who were in custody at the time, the magistrate issued a warrant for their further detention until they appear before the trial court on the 1st of October 2024. On that date, the trial court will become properly seized with their matter, whereupon the warrant in terms of which they are held in detention, having served its purpose, shall lapse. The trial judge properly seized with their trial will be able to deal with their application for bail pending the trial. The case of Mpofu and another supra dealt with the effect of a warrant issued by a magistrate in terms of Section 66, subsection 2 of the CP&E Act upon the indictment of an accused person to this court. The judgment did not touch on what would happen upon the lapsing of the warrant on the trial date set by the Prosecutor General in terms of Section 160 of the CP&E Act. That was not the issue before the court. The judgment never held that the lower court's judgment expired upon the issuing of the warrant of further detention by the magistrate. It is surprising where the applicants were getting their position in the judgment. Both Mr. Maduku and Mr. Chetero were waiving the judgment, which is HH 409 of 24, without reference to any particular part of the judgment they were referring to. It is further submitted that the provisions of Section 169 of the Criminal Procedure and Evidence Act are not applicable in the present case because the applicants were already in custody at the time of tendering their pleas to the charge. This provision is only applicable to accused persons who are out of custody. Section 169 of the 169 has the effect of terminating bail after the tendering of a plea in terms of Section 180 of the Criminal Procedure and Evidence Act to the charge by an accused person who is out of custody. It is submitted that only accused persons out of custody on bail pending trial at the time of the indictment, which bail is then terminated by operation of the law in Section 169 of the CPN Act, can make an application for reinstatement of their bail. An application for bail reinstatement is the one that can be said to come close to a fresh bail application. In the present case, the applicants have already read their defense outline into the record. The trial has effectively commenced. The case was postponed or adjourned to the 10th of February 2025 for continuation of trial. Under the circumstances, it is submitted that only Section 167, subsection 1 of the CPNE Act is applicable in casu. This section provides that 167, the accused may be admitted to bail on postponement or adjournment of trial. Subsection 1, when a trial is postponed or adjourned in terms of Section 165 or 166, the court may direct that the accused be detained until liberated in accordance with law or release him on bail, or extend the bail if he has already been released on bail, and may extend the recognizance of the witnesses. When the present trial was adjourned on the 5th of December 2024 to the 10th of February 2025, this Honorable Court elected not to exercise its discretion to release the two applicants who were already in custody. The Respondent is not going to speculate why this Honorable Court elected not to use its discretion to release the applicants or on bail at that stage. Ordinarily, this court acts upon an application by a party rather than mero motu. The applicants now apply for bail pending finalization of their case. In view of the fact that the lower court's decision denying applicants bail was never successfully appealed against, the compelling reasons that led to the denial of bail pending trial remain relevant. They still stand. Ordinarily, the applicants would have made applications on changed circumstances before the magistrate's court, which had initially denied them bail. Now that they are before this Honorable Court, it is submitted that they can make their application on changed circumstances in the High Court. The extant decision of the lower court against the applicants bind them, and such a decision by a competent court is respected by this Honorable Court. There is no provision cited by the applicants which say extant decisions of the lower courts are not respected by superior courts. It is further submitted that in terms of Section 170A, subsection 7 of the CPNDA Act, the record of bail proceedings in the lower court will form part of the record of the trial before this court. This section provides that, subsection 7, the record of the bail proceedings, excluding the information referred to in subsection 5, shall form part of the record of the trial of the accused following upon such bail proceedings, provided that if the accused elects to testify during the course of the bail proceedings, the court must inform him or her that anything he or she says may be used against him or her at his or her trial, and such evidence becomes admissible in any subsequent proceedings. The record of proceedings in the bail application in the lower court already form part of the trial record before this honorable court. The record includes evidence adduced by the state in establishing that there were compelling reasons for the applicant not to be granted bail pending trial. The acceptance of the record by operation of the law also implies that the extant decision therein is also accepted by this honorable court. Only applications on changed circumstances can be made after the initial denial of bail. What the applicants have done is not competent law. They cannot make a fresh application that will entail the adducing of fresh evidence all over again. The investigating officers and other necessary witnesses will have to be recalled, yet their evidence is already on record before this court. The fact that the application should be on changed circumstances is buttressed by the fact that the applicants now have the onus to prove on a balance of probabilities that they are proper candidates for bail on changed circumstances. What bail in non-third schedule offences is a right, with the state having to prove that there are compelling reasons to deny an accused person bail pending trial. Fraud is not a third schedule offence. In the present instance, the state has no onus to prove that there are compelling reasons before the applicants establish that there are changed circumstances. All that the state has to do is to rebut the existence of changed circumstances, or if the changed circumstances are proved to exist by the applicants, proof that compelling reasons still exist despite the established changed circumstances. Mike Chimombe says in paragraph 27 of his bail statement that the onus was on the state to show compelling reasons. The position at law that this position at law is erroneous. The state proved the existence of compelling reasons that led to the denial of bail pending trial in the lower court. The process of a fresh application cannot happen again. The present application should have been based on changed circumstances in terms of section 117A as read with section 116C subsection 2 of the CP&E Act. It is submitted that the provision for application for bail on changed circumstances is provided for in section 116 subsection C 2 of the Criminal Procedure and Evidence Act, chapter 9.07, which states that subject to this section, in section 32 and 34, a person may, upon an application made in terms of section 117A, be admitted to bail or have his or her conditions of bail altered. See if he or she is a person whose case is adjourned in terms of section 55(1) of the Magistrates Court Act, or in respect of whom or an order has been made in terms of section 351 subsection 4 by a judge or by any magistrate within whose area of jurisdiction he or she is in custody, provided that subsection 2, where in application in terms of section 117A is determined by a judge or magistrate, a further application in terms of section 117A may only be made whether to the judge or magistrate who has determined the previous application, or to any other judge or magistrate if such application is based on facts which were not placed before the judge or magistrate who determined the previous application and which have arisen or been discovered after that determination. Clearly, the legislature in its wisdom found it necessary to create a provision for an application for bail pending trial on changed circumstances. It is therefore necessary for the applicants to specifically state that their application for bail pending trial on changed circumstances is in terms of the above section. There is completely nothing amiss in stating that the application is based on facts which were not placed before the judge or magistrate who determined the previous application and which had arisen or been discovered after that determination. Timing of an application is critical. When a provision is specifically provided for, it should be followed to the letter. The old adage that says the end justifies the means is no application at all. To further demonstrate that an application on changed circumstances is the competent application where there is an extant judgment refusing bail, it is submitted that the Supreme Court acknowledged this position in the case of Neverson Namuka versus the State Supreme Court 69 of 21. The circumstances of the case is found in paragraph 2, where that is the applicant in that case applied to be admitted to bail by the High Court. His application was dismissed by Chitapi J on the 16th of February 2021. He thereafter petitioned the High Court again, seeking to be admitted to bail on the basis of alleged changed circumstances. The second application was dismissed. Aggrieved, he noted in appeal in terms of Rule 67, sub Rule 1 of the Supreme Court Rules, Statutory Instrument 84 of 2018. Honorable Mavangira J.A. held in paragraph 12 of her style judgment that, and I quote, "On the facts related to the above, I find no misdirection on the part of the court in its dismissal of the application based on changed circumstances. None has been established. In the circumstances, the appeal has no merit." It is apparent that an application on changed circumstances should be specifically applied for. The circumstances in the application on changed circumstances must be fresh and must not have been canvassed in the previous application in any competent court. In the case of State versus Barrows and others, 2002, Volume 2, Zimbabwe Law Report, page 17, High Court judgment, Honorable Shachwa J. as it then was, commented as follows on Section 116, subsection C2 of the CPND Act, and I quote, "The meaning of the above provision is quite clear. Where an application for bail has been refused, a further application for bail may only be made if such application is based on changed circumstances. That is, facts which were not placed before the judge or magistrate who determined the previous application, and which have arisen or been discovered after that determination. The reason for the rule is obvious. It is meant, among other things, to obviate the presentation of the same facts or variants thereof over and over again in a bid to obtain bail and helps in achieving finality in the matter. In the case of Daniel Reigns versus the State, HB 127 of 04, Honorable Cheddar J. remarked as follows at page 2 of his cyclostyle judgment, and I quote, "In determining changed circumstances, the court must go further and inquire as to whether the changed circumstances have changed to such an extent that they warrant the release of a suspect on bail without compromising the reasons for the initial refusal of the said bail application." In the Tichaona Katsamba versus the State High Court Harare 642 of 15, the Honorable Joe J. on page 2 of his cyclostyle judgment decisively held the following on bail on changed circumstances, and I quote, "Where bail has previously been refused and a further application is instituted, such an application can only be entertained if it is predicated upon changed circumstances, by which is meant that they must be fresh facts which were not placed before the court previously and were found out after the previous determination had been met. In the case of Chawuya, Chopper, and 13 others, I got Harare 8/16 of 22. Mutewezi J had the following to say on page 6 of his cyclostyle judgment on changed circumstances. In the case of Hope Chimono versus the state, HH 567 of 20, it was held that changed circumstances meant the existence of new facts which were not previously placed before the court that initially dealt with the bail application. It added that the facts must show that the circumstances have changed to such an extent that they warrant the release of the subject without compromising the reason for the initial refusal of the application. Admittedly, the court could have explained the concept more eloquently. That, however, does not detract from the fact that it essentially captured what is required in applications of that nature. In the case of State versus Chimombe, 2015, Volume 2, Zimbabwe Law Report, page 424, the court described the concept of to mean facts or circumstances which arose after the determination of the previous application. Alternatively, such facts could have been discovered either after the previous application. It follows, therefore, that it is improper for an applicant in a subsequent bail application to place before the court the same set of facts that he used to motivate the failed previous application. Given that understanding, that it reconciles well with the general statement of the concept by the court, it would amount to a nitpicking exercise where this court to agree with the appellants that the court did not properly understand the concept of changed circumstances. It did. Whether it then misapplied that principle is another issue. The first ground of appeal cannot therefore be sustained. End of quotation. From the foregoing, it is submitted that an application for bail on changed circumstances is not a novel idea. Such applications are entertained daily before the inferior and superior courts. Denying such a specific application which is provided for by the law in order to have a second bite of the cherry by regurgitating the same facts in the hope of getting a different favorable result is an abuse of this court. The trite law is quite elementary. For the avoidance of doubt, the state submits that it is its opinion that in an application for bail on changed circumstances, the applicant has the onus on a balance of probabilities to establish that there are changed circumstances. Once that onus is met, the state then assumes the burden to rebut either the existence of such new circumstances or prove that the compelling reasons to deny the applicant's bail exist despite the proven changed circumstances. The initial bail pending trial application should be distinguished from bail pending trial on changed circumstances, and further distinguished from application for reinstatement of bail pending trial. Different factors are considered in each of the applications. The resistance by the appellants to make a further application in terms of section 116C2 of the CPN has meant that there is no change in their circumstances. There is nothing for the state to rebut or show that there are compelling reasons in respect of any change in circumstances. It could not have escaped the attention of this honorable court that the applicants put up a brave show in resisting the commencement of their trial on the 1st of October 2024. Such resistance is not consistent with persons who intended to assert their right to a trial within a reasonable time in terms of Section 69 of the Constitution. The trial, which was meant to be concluded within the third High Court term of 2024, did not make any meaningful progress. Postponements were made at the instance of the applicant's legal practitioners, leading to the delay in the finalization of the case. Both accused persons deliberately failed to disclose that they had a pending case number ZAC HCR 5106 of 24, involving over $9 million. That matter is ready for trial, and applicants are going to be served with indictment papers during the first half of January 2025 to stand trial before this honorable court. In this undisputed second case, both accused persons were denied bail in the lower court. The second applicant, Mike Chimombe, appealed against the decision of the lower court. The appeal case number is HCH ACC 173 of 24. The appeal was heard before Honorable Chukowero J, who then dismissed it. Mpofu chose not to appeal against the decision of the court, lower court, in the second case, unless the respondent missed the appeal. The two went back to the Magistrates Court, where they made a further application on changed circumstances. That application was further dismissed. The two have since appealed to this court yet again in case number ACH ACC 206 of 24. The appeal is pending before this court. Clearly, the applicants have a sinister motive for deliberately failing to disclose such a serious offense that they are facing. With investigations finalized, the two were not candid with this court. If it wasn't for their late state, the applicants, in withholding the vital information, would have misled the court into arriving at a wrong decision. Section 117A, subsection 5, provides the following. 5. In bail proceedings, the accused is compelled to inform the court whether A, the accused has previously been convicted of an offense, and B, there are charges pending against him or her, and whether he or she has been released on bail in respect of those charges. Section 117A, subsection 8, goes on to provide that 8, any accused who willfully fails or refuses to comply with subsection 5, or B, furnishes the court with false information required in terms of subsection 5, shall be guilty of an offense and liable to fine not exceeding level 7 or imprisonment for a period not exceeding 2 years or both. It is submitted, my lord, that both accused persons failed to comply with subsection 5. The omission was deliberate. The applications by both applicants are in terms of section 117A of the CPLE Act, and hence they could not have missed what was expected of them. In so doing, both applicants potentially committed an offense. The interpretations given by the applicants do not hold any water. Section 117A, subsection 5B is clear. It compels an applicant in a bail application to inform the court whether he has any pending charges against him and whether or not he was granted bail in such pending charges. Mr. Maduku argued that such disclosure could be done upon request by the court. The state submits that such an excuse by the applicant does not hold water. It said, the strategy by the accused persons to make piecemeal bail applications in the two separate cases, one pertaining to the ghost tender and the second to do with City of Harare street light tenders, is meant to prejudice the interest of justice. They are on remand on both cases and were denied bail pending trial in both cases as well. The truth of the matter is that the two applicants are facing two serious charges which will both be tried in this court due to their gravity. Both cases will be tried in this court because there is prima facie case. It is submitted that both accused persons have not highlighted the changed circumstances from the time they were denied bail up to now. In actual fact, both applicants' situation has since worsened from the time they were denied bail in the Magistrates Court on the present case. As already indicated, in the second case, they were both arrested and charged with a serious case for which they were both denied bail. Moses Mpofu, in paragraph 19 of his bail statement, states the following. It is imperative to note that this section, which is section 50, subsection 1D of the Constitution of Zimbabwe, guarantees the right to liberty of an accused person pending trial. The right cannot be lightly interfered with unless there are compelling reasons justifying their continued detention pending trial. The respondent does not agree with the proposition by the first applicant that it is applicable to him and his co-accused. The reason for the disagreement have already been given. The first applicant, in paragraph 20 to 26 of his bail statement, goes on to regurgitate bail pending trial principles that were ventilated in his initial application for bail before the Magistrates Court. Such principles were considered, and therefore this cannot go on and on as stated by Honorable Shachwa in the case of State versus Barrows and others, Supra. In paragraph 27, the first applicant insists that there are no compelling reasons advanced by the state to justify this continued detention. One is seriously taken aback by this assertion, given the fact that he was denied bail after the state had established that there were compelling reasons. There is no provision that compels the state to periodically and continuously prove the existence of compelling reasons to justify the continued detention of the applicant in the absence of changed circumstances. Unless the lower court's decision denying them bail is set aside by a superior court, the applicants will remain in custody. It is in their best interest to be tried as soon as possible without the two further delaying the trial proceedings. The first applicant, in paragraph 29 of his bail statement, says the state's case is hopeless. Such belief must be translated into action by their demand for the finalization of the case. The respondent is convinced that the applicants are deliberately avoiding to go to trial. The first applicant made a surprising remark in his application when he said, and I quote, "If we are going to trial at all." This was a clear indication that they are avoiding the trial on the merits. That cannot be consistent with their belief that there is no prima facie case against them. The second accused, in paragraph 28.5, states the following on the issue of the finalization of the case, and I quote, "The applicant has already spent almost 6 full calendar months in remand prison Yet the trial may not be complete in the near future, given the constitutional litigation that has preceded the trial, including the fact that the applicant is in the process of preparing an application for direct access to the Constitutional Court against the dismissal of his referral application. It is apparent that the two applicants are not entertaining the conclusion of the present trial within a reasonable time. They have declared such a position in their application. The state contends that the issues intended for referral have no direct bearing on the conduct of the trial before this court. The respondent believes that there is a prima facie case against the applicants to warrant the trial. The respondent is not going to further argue his case before the case goes to trial. However, the state papers show a prima facie case. What Mike Chimombe said in paragraph 28.5 of his bail statement, that he is in the process of preparing an application for bail I'll take that again. What Mike Chimombe said in paragraph 28.5 of his bail statement, that he is in the process of preparing an application for direct access to the Constitutional Court against the dismissal of his referral application is his right. However, that assertion has no weight at all. There is no application that has been made for direct access yet. In any case, the issues that were raised during their application for referral cannot detain this court. Even if they were to be granted direct access, that won't affect the progress of the trial before this honorable court. The respondent, having had the application for referral and the thorough judgment by this court, it is clear that an attempt for direct access will be ill-advised, for it will be an exercise in futility. Mike Chimombe also says in paragraph 28.4 of his bail statement that the case against him is so weak as to be almost non-existent. He further says that he won't abscond because there is nothing to run away from. Such an observation cannot hold water given the amount of resistance he is putting up to avoid trial. The amount of time he has spent pursuing peripheral issues, arguing that it is his constitutional right to do so, was enough to conclude the trial on the merits. Clearly, the applicants are resisting to go for trial because the state has a rock-solid case. The likelihood of both applicants absconding is high. The two applicants had a privileged life before their arrest. They have now experienced hardships associated by being in custody. Their criminal legal problems have increased. All these factors will entice the applicants into absconding beyond the jurisdiction of this court. Both accused persons are men of means. It is not in dispute that both accused persons were paid over USD 7 million with nothing recovered. Upon their indictment, the applicants were served with detailed summaries of the state case together with copies of documentary exhibits. While the witnesses' statements were provided to them, they made a request for further particulars and such information was furnished to them. The two are properly informed about the gravity of their situation. They now appreciate that the state is going to adduce serious evidence implicating them in the commission of the offense. In the case of Tapfuma, State versus Tapfuma, High Court Harare, case number 565 of 19, the Honorables were first stated the following on the fact that the applicant had cooperated with the police during initial stages of the investigation. and I quote, the court's attention was drawn to the events before the appellant was arrested. That investigations commenced in December 2018. He was cooperating with the investigating officers. He had the opportunity to abscond, but he did not. It was submitted that the state did not point to any instance where a likelihood to abscond can be inferred from. The court is alive to case law that such should exist before a finding can be made. However, each case depends on its circumstances, taken in totality with other factors. It is my considered view that at the time of the investigations, the circumstances were different. There was no real incentive to abscond. It was an investigation. The appellant has since been arrested. He is now aware of the evidence and the likely turnout. This creates a different outlook of the circumstances. There is no reason to interfere with the magistrate's decision on this aspect. The sentiments by the Honorable Mpofu J in the State versus Tapfuma case Supra are quite relevant in the present case. No release on bail conditions will be enough to allay the fears that the state is entertaining. The two will either abscond or sabotage the state case by interfering with witnesses. It is submitted that the applicants have failed to establish that there are any changed circumstances that warrant their release on bail pending trial on a balance of probabilities. The compelling reasons established by the state still stand. Wherefore, it is prayed that both applications be dismissed for lack of merit. That is what the state, that will be the state's response to the application that is made.
Well, just before you resume your seat, can you go to section 169 of the Criminal Procedure and Evidence Act? Yes, you have submitted that it has no relevance to this matter without saying why. Or maybe if you said I didn't quite get the gist of that. Can you explain why 169 is not applicable?
Thank you, my Lord. If one goes to the heading of that section, it says termination of bail on plea to indictment in High Court. That will be termination. So the section, by the mere reading of the heading, it is talking about the accused persons who had been admitted to bail. Those are the only people who can have their bail terminated. But in respect of an accused person who is already denied bail, there is no termination of bail because that accused person was never on bail. So there is no bail to terminate. I think I don't need to get into the rest of the section. But
yes, the problem is when I know that sometimes headings may give a clue, but we are interpreting the section.
Yes.
We are not interpreting the heading.
If I may read loud, the section says if the accused is indicted in the High Court after having been admitted to bail. So I must stress in the other line.
I have already emphasized that.
His plea to the indictment shall, unless the court otherwise directs.
Very well. You can pause there for a while. What does that mean? Unless the court otherwise directs. How does the court do that?
Yes, but that is why the state was saying the present scenario is not applicable, because they are talking about.
I want you to be very careful.
Yes.
I'm not arguing the applicant's case. I'm not implying that it applies to the present. You understand? I simply want to understand. There's convergence. Both parties are in agreement that 169 does not apply. But I want to know, I asked the applicants why they say so, they explained. I want to know from your side why you say so. Not that I really believe that it applies or that I've already made a finding that it does. I simply want to know why you say so. So I asked the same question to applicants' counsel. What does that mean unless the court directs, otherwise directs? What does that mean? How does the court direct that? Under what circumstances? How does that happen?
Maybe this time the state needs to clarify this response that it's going to give.
Yes.
But by first clarifying that what the court has to direct on, it is giving reference to a person who was on bail.
Yes.
So this is the person. This is the kind of a person who is being alluded to.
Yes.
So the direction that can be given to the court
Yes.
is on whether that person has to remain out of custody, whether on further conditions or on the same conditions that were given.
Oh, okay. So your point is that it's not even necessary to interpret it because that is not the situation obtaining in this particular case.
Indeed, because it is written here that after having been admitted to bail.
Yes.
So they are talking about an accused person. The accused person who is being spoken to is an accused person who has been previously been admitted to bail before indictment.
Yes, that's quite clear. Yes. Anyway, you can proceed. You can then proceed and read the rest of the section.
Yes. It says then have the effect of terminating bail, and he shall thereupon be detained in custody until the conclusion of the trial in the same manner in every respect as if he had not been admitted to bail.
Okay.
So this person who had been admitted to bail, if the court does not decide otherwise to maintain his status of being out of custody, that person will remain in custody. Yes. And the action that he is going to take is the action that might be taken by the person who had already been denied bail. That if he wants to be admitted to bail, he can apply for bail in terms of section 117A.
Okay. I'm quite, yes. So the legislator could have simply ended where it says, shall thereupon be detained in custody until the conclusion of the trial. Full stop. The legislature could have ended there. Isn't it?
Yes.
Yes. So what is the meaning of the, what import do you give to the rest of that, which says, in the same manner, in every respect, as if he had not been admitted to bail?
The rest of that sentence, it is giving guidance to the person who would have not been admitted on bail that that person was enjoying before he was indicted. So the action that he will take is similar to the action that is taken by the person who had previously been denied bail, who is not affected by this section. By that, he can apply for bail.
So
whatever reason.
Oh, okay. Okay. So you are saying that, so it means that a person who was denied bail before, you said a person who was denied bail before does what?
The one who was denied bail, according to the submission that I have made to the Honorable Court,
may then apply for bail.
We will have the judgment denying that accused person bail will remain extant. If that person intends to take action for his release, he has to deal with the reasons that led him to being denied bail. And that is why it then brings us to section 116C subsection 2, that he has to come before the court and ask the court that the reasons for which he had previously been denied bail have since changed. There are now changed circumstances which would persuade the Honorable Court to deny him bail. So the argument of the state in this matter is that the extant judgment denying an accused person bail cannot be wished away, cannot be ignored, because that is the very reason why the accused person remained in custody, because there were real fear. There was real fear, which was acknowledged by the court, that if he were to be released, then what was the fear that was being entertained might
so a person, very well. So is section 169 really irrelevant?
It is irrelevant. That's why the state has to touch on it and say why it is irrelevant. Yeah, because the argument that might have been occasioned was that the cancellation of the bail, it means there was need for a fresh application, which the state was saying it was the application for reinstatement of bail. It's akin to a fresh application. Because he has to prove all the factors in section 117.
I just want to. I thought your interpretation is that what the law is saying is that a person who is who has been denied bail before is expected to make a bail application if so inclined, based on new facts, and that then should be the situation with somebody who was previously on bail, whose bail is not renewed or extended by the court.
Irrespective of someone whose bail was cancelled, there were never any compelling reasons.
So what happens to what we are in agreement this far? This is a person now who has now reached the trial court and has pleaded to the charge. That then he continues to be in detention in terms of what?
Which one? The one who was previously out of custody?
No, the one in the situation of the accused persons. If we follow let's see. We started off with these persons being denied bail,
yes,
and then they were then indicted, yes, and because they had been indicted, a new transitional provision took effect, in terms of which they were then detained in terms of a warrant issued by the magistrate. Which warrant was a transitional provision, which then delivered them to the trial court, isn't it? Now they've appeared before the trial court. What then happens?
I think what the state wishes to make clear, my lord, is that the issue of the warrant is explained in HH 409 of 24. What was that the denial of bail it consequences?
Consequences, yes.
Which were that a warrant was going to be issued. Between the time of indictment and the appearance before the trial judge, yes, that person could not make an application.
Yeah.
Yes. There was a limitation which was created.
Okay.
In section 66.
Such a person may not, shall be detained until he appears before the trial, yes, court. We are in agreement.
That was
now the person has now appeared before the trial court, and the person is pleaded to the charge. What then happens? We are in agreement that every warrant is either cancelled or falls away. Now they've appeared before the trial judge. Naturally, the warrant has served its purpose, it falls away. And detention after that?
What has to be made clear, my lord, is that the issuance of the warrant did not entail in the cancellation of the bail. The bail judgment denying the accused person bail remained extant. What only it did, it had the consequences of the issue that you can't apply for bail, but the judgment denying bail remained in existence, and the reasonable fear for the accused person having been denied bail, they always remain in place. That he was likely to interfere with evidence, likely to abscond and so forth. All that which was held by the court
not affected by the warrant.
were not affected. So that judgment did not go anywhere. but it had other repercussions.
So where does it go in the meantime?
It doesn't go. It doesn't go anywhere. But however, it has got certain consequences. It has resulted to limitations to his right to apply for bail during the time between the indictment date and appearance before the trial judge. So, if the
in other words, the legislature could have simply said that, notwithstanding or upon indictment, any person previously denied bail shall remain in custody. What's the purpose of a warrant?
The warrant is the state would hazard an explanation. The warrant, because the accused person was in custody at the time of the indictment, that he was said you were supposed to appear before the court. The legislature, in its wisdom, found it necessary for that person to remain in custody. In actual fact,
that person is already in custody.
Yes.
The legislature did not have to worry about that, because that person is already in custody. What was really the need for that intervention of the issuance of a warrant?
My Lord, this was the old position which was maintained before the 2013 Constitution, where a person upon indictment was put in custody. But with the advent of the Constitution of 2013, the legislature found it necessary to keep in place the position in respect of a person who was in custody. That person should remain in custody until that person appears before the trial judge.
Who then does what?
Who then can seize with the matter, can then look at the issues, because the legislature did not want any other person to intervene.
I agree. You seem to be in agreement with that. The legislature is, the intention is very clear. A person who is in custody at the time of indictment is detained until he or she appears before the trial judge.
Yes.
And then when he appears before the trial judge, is the judge precluded from considering whether or not he should be out of custody or should be admitted to bail?
No, the judge that will amount to descending into the arena. A trial judge cannot talk about it. The issue of bail is
No, I'm not saying mero motu. Yes. An application is presented to the judge. Is he precluded from granting bail?
The judge it is within that right to give bail. But however, because there's an extant judgment that denied bail can only be on changed circumstances.
Changed circumstances. That's what you are saying.
Yes, because the whole process according to Bunu to Shachwa cannot be said because it was in the magistrate court. We are going to disregard, although the record in the magistrate court is before the court. The High Court is saying we are going to carry our own processes from the beginning. The magistrate court is a competent court. Its decisions are binding on everyone, including, I'm sure including this court, unless the decision has been set aside.
Thank you very much. Nothing else? Thank you.
That is all, my Lord.
Thank you.
Thank you.
Yes, Mr. Tutin.
Thank you very much, my Lord. If I were to summarize the position of the state as I've heard it, the position of the state is simply to say we have no onus to prove any compelling reasons. The state has not, in all its submission, given any compelling reasons.
Let me correct you there. I think the state says the compelling reasons, a finding on compelling reasons has already been made, and the finding remains extant. So by virtue of that, they need not say anything further.
Yeah, that is what they've said. But I'm saying they are not stating for themselves that these are the compelling reasons. I will hazard to say, my Lord, the state has not adopted even the evidence that it laid in the magistrate's court. It has not attempted to adopt that evidence. It has not placed that evidence before the court. It has made reference to provisions of the Act which says that the record of proceedings must form part of these proceedings. But that is not to adopt those reasons. It would have been different if the state had said, we proved compelling reasons in the magistrate's court. And the magistrate court was with us on these compelling reasons. We are now adopting them in these proceedings as if specifically averred.
Okay.
Which is a completely different...
Can I, because you are speaking last, you are responding on a point of law.
Yes.
Can I place before you or put you how I understand the state, in, where you are different with the state,
Yes,
the points of divergence.
Yes.
The position by the applicants is that this is a bail application,
Yes.
which be considered as a fresh application,
Yes.
in terms of which the state must lead evidence or demonstrate that there are compelling reasons, for their for denying bail.
Yes.
Otherwise, the law is clear. If the state does not demonstrate that, then bail must be granted.
Indeed.
The state is saying, well, no, this is a further application
Yes.
because it is common cause that they were denied bail before.
Yes.
And in a further application, you are actually recognizing the fact that there is a decision which remains extant, which found that there are compelling reasons. And we don't need to go through that process again, because that judgment is extant, is already there. We don't need to go further. We only need to demonstrate that there are no new facts which change that position or which affect the decision already made. So it is either the state is correct in that submission, in my view,
Yes.
in submitting that this is a further application, in which case then they would have no need, and would there be any need for them to argue compelling circumstances?
The state is starting off from a position where it is characterizing our application to be saying it ought to be a further application.
Yes.
Right?
Yes.
So the moment it does that, my lord, it has started on stage number 2. My submission is the first question that must be answered by this honorable court is it a fresh application or is it a further application?
Yes, I'm mindful of that.
So I'm saying if we start off from the position that, assuming this court is with us to say this is a fresh application, it would mean that in that application the state has failed to provide any compelling reasons because it has not adopted.
Yes.
But I will then get to that extent, my lord, where the state then says it is a further application or an application of changed circumstance. I'll get to that. And then I will deal with what they are saying, or to be saying this has already been determined.
So
in a way, they are saying it's res judicata, in my view.
Yes.
Yes.
So the first issue to be determined,
yes,
is whether this is to be considered as
a fresh
whether you call it a fresh or a bail application, which is what do you call it? A fresh application, or what is it?
I would propose, my lord, that we follow this diction of
a fresh application.
Fresh application and further application. I will say so, my lord, because this word started from the state. The word fresh application. And I'll demonstrate that, my lord. I will refer this honorable court to the record of proceedings of the appeal between the accused persons and the state. Right? In opposition to the appeal, this is what the state says in paragraph, in page, in the very first page. They say it naturally follows. The state started off by a point in limine, which was appealed by this court.
Yes.
In motivating its point in limine, it says this. I'll quote verbatim. It naturally follows that interlocutory applications that were pending before the inferior courts became moot. When Section 137 of the CPE Act is read together with Section 66, subsection 2A of the same Act, it becomes clear that the pending appeal by the applicants has been superseded by event and has become moot. The interpretation of the new section, namely Section 66 2A and 137 of the CPE Act, when read together, is that upon indictment, the applicants are referred to this honorable court without any pending applications. The present appeal is one such an application that has been rendered moot. The applicants were indicted whilst in custody and will remain in custody unless a fresh bail application pending trial has been before this honorable court. This is what the state is saying.
My Lord, with respect, I just want, if I may be allowed to object. Where my late colleague is reading from, it's an application which was by this honorable court. I don't know who was presiding over it. The state was, myself in particular, I was not a party to that application. I don't know where that is coming from.
Which application?
Where my late colleague is reading, the passage that is reading. It's on another application which was done elsewhere, not before this honorable court.
I'll assist, I'll clarify. Yes. Or rather, I will not rely on this, my Lord. I will rely on the judgment of this.
I will tell you what, Mr. Jetero, I want to, I have difficulties in perhaps putting across my point because of this choice of words, fresh application, application space. All I am saying is that there's no agreement between the applicants and the state, isn't it? The applicants are saying this bail application must be considered without any reference to any earlier application. So, because if we start talking about fresh application, still we get confused. You see, I tried to say whether this is a fresh application or an application based on changed circumstances. I still got stuck because both can still be described as fresh applications. You see, when an application has been made and it has been determined, any further application can be described as a fresh application. But what the dispute that I have between the state and the applicants is that the applicants are saying you must not pay attention to any application that was made before the magistrate because it's irrelevant. I must just consider this bail as if the applicants never applied for bail before. I'm looking at I thought that is the position taken by the applicants.
The position?
Yes. Then the state is submitting that you may not overlook the fact that there is a decision already which remains extant. So if you take that into account, then this is a further application. It doesn't matter that it's before a judge. I think that is the only difference here. Whether or not it's a fresh application, that is a very tricky word. Fresh word application.
My Lord, I follow you, my Lord.
Yes.
To answer that question, my Lord, this is a question that has really been dealt with by this honorable court before. It is an issue that has confronted this honorable court. The question there is whether or not the decision of the magistrate court is extant.
Yes.
Yes, that is the question.
Yes.
Yes, my Lord. So we may say fresh application or whichever words we want to use.
Yes.
But the issue is whether or not the decision of the magistrate court is extant.
Yes.
When faced with this issue, in the matter between Mpofu and Chimombe versus the state, this court made findings. And I will respectfully submit that this court is now functus official as far as that is concerned.
I'm not, I think you really are not understanding. I really agree that there is that judgment, that there are those pronouncements. I just want you to help me in appreciating the dispute that I have to resolve. You understand?
Yes, ma'am.
And I'm trying to couch it so that if I am presenting it incorrectly, you may then correct me. I'm not taking a position. All I'm saying is, I understand the real dispute between the parties to be that the applicants are saying this is an application which must be considered and deliberated upon as if no other application was made before.
Yes, my lord.
It's an application where the state has the obligation to where bail must be granted if the state does not show that there are compelling reasons.
Yes, my lord.
Isn't it?
Yes, my lord.
So that is the position that you take. In other words, I must disregard or disabuse my mind of the fact that there was an application that was made, because it is irrelevant.
Yes, ma'am.
It is not that is not a fact anymore.
Yes,
it has become irrelevant. So I must now consider afresh who they are, where they come from, where that they are employed. The usual structure of a bail application.
Yes.
You see what I'm saying?
Yes,
whether they are flight risk and so on, and then the state must lead evidence or demonstrate from the agreed facts that there are compelling reasons.
Yes, ma'am.
And that I must not be affected by a previous decision. That is the position. The state is saying, no, we don't need to do that. You must still recognize the fact that the appellants have already been denied bail, and that judgment remains extant. So the appellants can only succeed if they show new facts, which were not before the court that denied them bail, and that those new facts affect the decision already made.
Yes.
So that is what I must decide. Yes, in which case, if you accept, that is the way I should approach the matter. That is that is the number one issue raised by this application and the opposition to it. Yes,
my lord. Maybe if you may allow me to read the finding of this honorable court in respect to answer to that question, my lord. This honorable court says, I do not agree with the state that at this stage the appellants can make a fresh bail application before any judge of the High Court. In terms of Section 117A of the Criminal Procedure and Evidence Act, an accused person may at any time apply verbally or in writing to the judge or magistrate, as the case may be, before whom he or she is appearing, to be admitted to bail immediately, or may make such application in writing. This court then goes on to then said the option of applying for bail should not be taken as an opportunity to forum shop. The court then goes on to say the appellants were indicted to appear before the trial court in the High Court. They are now accused persons facing trial in High Court. And in terms of Section 117A1 of the Criminal Procedure and Evidence Act, their application to be admitted to bail pending trial will be heard by the judge to preside or presiding at their trial. Yes. If the procedure of the indictment is read as a whole, including Section 169 of the Criminal Procedure and Evidence Act, it becomes clear that the legislative intention was to, as much as possible, give the trial judge the prerogative to determine the issue of liberty pending trial. The logic is simple. After indictment, the trial court takes into account not only the facts which linked the accused persons with the charge at their initial remand, but also the evidence now presented with the indictment papers, and may want to look at the accused person's defense in the face of such evidence. The intention is also clear from the difference in wording between Section 662 and 662A of the Criminal Procedure and Evidence Act. If a person who is committed for trial has earlier been granted bail, it then goes to look at those two scenarios.
You are reading from the judgment?
Yes, my lord, from the judgment of this Honorable High Court.
The judgment that was cited yesterday?
No. Yesterday we cited, I'm reading...
This was the judgment in the bail application which was removed from the...
in the appeal.
in the appeal.
Yes, my lord.
I hear you. Perhaps you don't understand. I just want you to help me to appreciate the issue that I must determine.
Yes, my lord.
The issue that I must determine, you won't find it in the judgment. All I'm saying is that is it correct that what I must determine first of all, before going in further into the merits of this matter, is whether or not this should be considered as an initial bail application, unaffected by a previous application, or whether it is an application which must take into account a previous application.
Thank you, my lord.
Yeah, that is all. Is that one of the first issues that I must determine?
Thank you, my lord. If you could just go. Yes, my lord. I'll start off, my lord, by the Constitution, my lord, which guarantees the right to bail at any stage. I will traverse through the stages at which bail can be considered and granted by a court.
So what do you understand my question to be, Mr. Chief?
I do, my lord.
What do you understand it to be? What am I trying to find out from you?
You are asking me, my lord, when this court is dealing with this bail application, what should it look at it as a bail application that is coming as a further application or not?
Okay, maybe without suggesting anything, let me ask you a question which gives you an opportunity to identify the issues for me. What are the issues raised by this application?
The issues raised by this...
and the opposition did. What are the issues? If you were to identify the issues so that you guide me in preparing judgment, what are the issues raised by this application? You say issue number 1, issue number 2, issue number 3.
Yes, the issue number 1, my lord, is whether or not the applicants can be granted bail pending trial.
Yes.
In dealing with that...
no, don't tell me. Is there another issue?
That is the sole issue, and if so, on what terms? If they can be granted bail, on what terms?
I see. Oh, well, if that is how you identify the issues to be, that's fine.
Yes, my lord. So, and then I'm going on, my lord, to submit that if one looks at it, if a person is arrested at police, the Act talks of a scenario where a person can be granted police bail. I'll call it police bail. Then, when a person is then taken to the magistrate's court and is put on remand, the magistrate's court determines a person's bail based on the Form 242, which is a remand court bail. I would call it that.
Yes, let's call it that.
That stage then traversed to a stage where a person is maybe now facing trial. All the evidence has been conducted, and now trial is about to begin. The law, if properly read, provides for a scenario where a court can look at issues differently or can look at issues afresh at that stage, because it's now a different stage. The law goes further to a point where even when a person is then convicted, a person can also then be granted bail pending appeal. Now, the stage where we are at, my lord, I would submit is a stage where we are now faced with a trial. This is why, my lord, in my respectful view, you would find section 169 clearly mentioning what happens when a person pleads. It provides a marking, a reference point, a distinction from the time when somebody was in police custody, from the time when somebody was in a remand court to be brought to trial. Because the remand process, in my respectful view, is a conveying process of an accused person to face trial in the High Court. So we are having two people who are coming to face trial in the High Court. One has already been admitted to bail, one has not been admitted to bail. In my respectful view, section 169 goes to show that as at the time that a person pleads, the status of the case has changed. And this court is therefore entitled to deal with that issue of bail. So in both cases, whether you have been in custody, because when you are coming on the basis of a warrant, my lord, the warrant which is issued by the magistrate's court determines and signifies the change of events, that you are no longer in custody because I denied you bail, but you are now in custody because I've issued this warrant. Otherwise, there will be no need for a magistrate's court to issue a warrant to an accused person who the magistrate has denied bail.
So what is the issue that you're tackling there? When you are saying that 169 demarcates, draws the line, what issue are you tackling?
I'm saying the issue that we are now faced with, the application for bail pending trial, is an application that must be dealt with as I would say fresh application, or as an application in terms of 117.
As an initial application.
As an initial application.
So I have to resolve that issue. Yes. Whether I should deal with this matter as an initial application,
yes,
and or whether it is an application, or whether it is a further application, which takes into account.
Yes.
So why are you not identifying that as an issue?
My lord,
I've really been at pains to say that is the first thing that I must determine. Whether or not I must just deal with this as an initial application, which has no reference to any other events before, or whether I must treat this as a further application. Because that would then decide matters to take into account. But you are refusing to acknowledge that as a fact, as an initial, as the first issue to be determined. Because if I determine that this is an initial application, then the approach is different.
My lord, I'm not refusing, my lord.
Yes, that's why I said now identify for me the issues.
To say in determining this matter, this court must take into account.
So what is the first issue?
By the court.
So what is the first issue?
Whether or not this is an initial application or further.
What is the nature of this application?
This is an application for bail in terms of.
Yes, I'm not asking that question. I'm just, because you are now closing submissions, I don't want to approach the matter wrongly. Is it correct that I must ask myself, what is the nature of this application? Is it an initial application or is it a further application? Am I correct in identifying that as the first issue to be decided on?
Yes, you'll be correct, my lord. And in doing so, my lord, as what the applicants had indicated, the applicants argued that this is an initial application.
No, at that point has been argued thoroughly.
Yes, my lord. And they go further, my lord, to say even if it is not considered as an initial application, okay, alternatively, it would still fit into the shoes of a further application.
Yeah, there are new facts.
Yes, they are.
Yeah, we are allowed to couch our issues like that.
Yes.
Even if it is a further application, yes, there are indeed facts, yes, that warrant this court, considering, dealing with it as a further application.
Yes, my lord. Yes, my lord. So,
yes, proceed.
So the point that I was making, my lord, was that this honorable court has already determined the stage at which an initial application can be made in the judgment that I've referred to. So that point is now a determined fact. It cannot be departed unless if the state has shown that it must be departed from.
So when 169 says a person whose bail is taken away in terms of section in terms of by way of pleading to the charge,
yes,
and is not really the judge does not exercise his or her discretion in favor of that person, shall remain in custody until the end of the trial. Is it in every?
As if he had never been admitted to.
I think let's get it from the act itself. Shall be detained in custody until the conclusion of the trial in the same manner in every respect as if he had not been admitted to bail.
Yes.
What does that mean?
Yes, my lord. It means that if a person was out on custody, if that person pleads.
Are we particularly referring to the one who was not admitted to bail? What is it telling us?
169 does not specifically refer to a person who is in custody already.
No, we want to understand what is meant by in the same manner in every respect.
Yes.
Because we must understand what that means.
I do, yeah.
What is because that situation which would apply to a person who has not been denied bail must be identified.
Yes.
What is it? What happens?
Yes.
And now that is what must happen to somebody whose bail has been taken away.
Yes.
So in order for us to understand that, we must first of all agree what happens to a person who has not been admitted to bail before at the time that is indicted.
That person must be detained, my lord, unless if that person makes an application such as this one.
Okay.
And
So that is
then
what it
granted,
means. Yes.
that application.
Okay.
So to both people.
So that's why I was asking both of you why you say that 169 does not apply to the accused persons.
Well, my lord,
Because it wants us to understand what happens to those that have been denied bail. Do you understand? Or those that way. We must know what happens to them so that we know how that applies to one who was on bail. So somehow you read it backwards, you understand, in order for that 169 to apply, you must first of all have consensus or agreement or an interpretation as to what happens to a person who was in custody at the time that they plead to the charge. What happens to them?
Maybe I'll qualify it to say that it applies to the extent that it shows that upon a plea having been entered, that person can now proceed to apply for bail as an initial bail application. To that extent, Section 169 shows us that the legislature intended to put a mark, as it were, to the stage that would have been.
So a person who was not admitted to bail is expected. Okay. So in other words, it simply says a person who was not admitted can still apply for bail. Yes. That's what you're saying.
In other words, it equates an indictee who was out of custody to the one who is in custody.
Yeah, and somehow the yardstick is the situation that affects a person who was who was not admitted to bail.
Yes.
That's the yardstick. So we must understand what is that situation. Yes. So that when we understand, then we are dealing with the accused persons. What does the law expect of them?
I'm indebted, my lord. I'm indebted because it clarifies the issues that both accused persons are now regarded as detained. They are now in custody, both of them.
Yes.
Whether you have come via 661, whether you have come via 662. And it therefore then sets a yardstick of an initial application of bail pending trial, which is its own considerations, which are very different from the considerations that would have been entertained by a magistrate when he or she was faced with a form.
So it sets a yardstick for an initial application. That's what you're saying.
Yes.
Very well. Anything else?
Yes, my lord. So I've explained this, my lord. And to say that a determination of the magistrate's court is extant, my lord, would be wrong because this honorable court has already ruled on whether or not it is met. So there is a judgment by this honorable court which says that ruling of the magistrate's court is extant. So for the state to argue that it is binding upon this honorable court would be wrong, for that reason that it has been determined to be moot. And secondly, for the reason that when the magistrate's court was dealing with this issue, it was faced with a Form 242. It was not faced with a full docket. It was not faced with a summary of the witness statements, with a summary of the exhibits that the state intends to rely on. It was not faced with a defense outline of the accused person a situation where this honorable court, as a trial court, is now properly dealing with issues, ventilating the issues. And I believe, my lord, if properly read, the legislature is very clear to say that bail issue can only be dealt with by the trial judge. There is a reason why it does not give that power to any other judge. You would follow my lord that this is why even this application is had to be placed before yourself, because you are the trial judge, and as a trial judge you are in a different chair from any other judge who is not going to trial this matter. So that is indicative of the fact that it is an initial matter. If it were a further application, as the state is submitting, my lord, that application can only be entertained by a magistrate. It cannot be entertained by a judge. So, say for example, we assume that this is a further application, my lord. We cannot make a further application to a judge when the initial application was made to a magistrate. It is only a magistrate who did not hear that other matter who is empowered to then entertain that application. So this is why I submit that for us to call it a further application would be, with all due respect, to reduce this one of court to being a magistrate court. And this is why the Act specifies the different stages that an accused person goes through. It's clearly to ensure that when a judge is now faced with a matter as a trial judge, he's not bound by the decision of the magistrate court. Even if that person was out, that liberty is taken away. Meaning, whatever the magistrate had determined has been disregarded. And the court is now empowered to then entertain the issue as an initial issue. So, with that in view of the whole legislative framework, my lord, I submit that it shows that such kind of an application, if we had made a bail application and it had been refused, like the bail application that we had made before, it would then qualify as a further application. Or assuming that, my lord, this application is dismissed and bail is not granted, and at a later stage we then make another application, that would be a further application. But for all intents and purposes, this is a fresh application in terms of the law, if properly read. That would be my submission in respect of that matter. I would just wish to quickly move.
There's also another point which I forgot. The registrar directed the applicants to file an application and not to revive that application which was moved from the roll. Was it not because 3 months had lapsed?
I had not counted the months, but
because
I
you
did not
filed your
think
bail
that the 3
application.
months had lapsed, my lord.
It
was before the expired, because
Oh, it was.
the last application, my lord, was made on the, if you could just bear with me.
When was it removed from the roll?
The judgment that I was referring to is a judgment of...
When was the order removing that matter from the roll?
Let me... If you could just bear with me. If you could just bear with me, I'm looking for the judgment. The judgment by this honorable court, my lord, was issued on the is it 11th of September. I read this
I think there's a narration.
11th of September, yes, my lord.
That's when it was removed from the roll.
Yes. And the initial...
And when was this application made?
This application was then filed on the... Okay, my lord, maybe before we get to when this application was filed, we need to to first determine the date on which we attempted to file the application and the registrar refused. I don't know.
Okay, I get your point. Well,
because the
what is
registrar,
it?
in our respectful,
There was a narration in the
refused.
application itself. I just wanted to be clear on that.
Yes, my lord. I think we must be clear with those dates, my lord. The request was initially made. My learned colleagues would help you with this. They can look into that.
But well, yeah, while your colleagues are looking into that, you can then. But they also want to listen and understand your submissions.
Oh yes, my lord. Maybe let us deal with it. I see my. The request was done on the 10th of December, so it was done a day before the expiry of the 3 months.
Well,
So it was in time. So we actually believe the registrar was erroneous in declining to accept that application. In fact, that application ought to have been re-enrolled, because also this is what the Honorable Court had ordered.
Very well, thank you. I'm clear on that now.
Thank you, my lord.
Is there any other point of law?
Yes, my lord. So, my lord, following from that, it means that the state has an onus, if it is taken to be an initial application, to give compelling reasons, and the state has not. And the state has also indicated that it has referred to a case of Neverson versus the state. 69 of 21, I think SC 69 of 21, which is not applicable to this particular matter, because that matter was dealing with a further application, which is inapplicable to this particular matter. The state has also said that the accused person has been resisting trial ever since, which is not a correct allegation against the accused person. The accused persons, if at all, have been diligent. The accused persons have attempted to appeal against the denial of the bail. They've attempted to make an application for bail, and they also attempted to enroll that application for bail, and they have now applied for bail. So they've been diligent in fighting for their liberty and bail. And the issue that the applicants raised constitutional issues is not and cannot be held to be a resistance against the trial. In fact, it is part of the trial proceedings, because what the applicants did is to exercise their rights. So it will be inaccurate and it will be not correct at all for the state to allege that the accused persons have been resisting. If at all they are not resisting, they are not afraid to face this trial, which they, in their view, is a trial where the state is doomed to fail. The state has also dealt with the alleged failure to disclose the aspect that they are facing another charge. My lord, as we submitted before, my lord, that issue is not before the Honorable Court, that failed. So it is an exercise in futility. If the state calls upon this court to make a finding of whether or not they failed to disclose, that finding leads us to nowhere. Because what the state is saying in effect is, if the court is with them that the accused persons have failed to disclose, therefore the bail application must be dismissed. It is not one of the bail considerations of whether or not a person is disclosed that there is another matter. So it is an exercise in futility. But at any rate,
you said the alleged failure to disclose a pending case.
Yes.
is what is not before
It's
this court.
an exercise in futility. It's not before this honorable court. The accused persons are not facing a charge of breaching the section that requires them to disclose. That section creates an offense, and that offense must be tried by a trial court, which must come to a finding.
I see.
It is actually inviting the honorable court to carry prejudices against the accused persons, which are not correct. The accused persons have disclosed already, and we have indicated that even if it were to be held that they have not disclosed, it goes further to then indicate, or it is indicative that there should be an id of deliberate withholding of information. And I agree with the submissions that were made by my colleague, that it only goes to show that they are compellable to disclose. And if asked, they must disclose, as what has happened. The state has raised that issue, they both disclosed that there is a spending net. My learned colleague has also related to the aspect of the direct access application, the constitutional court application. My Lord, the state would appreciate that the failure of the accused persons to apply to the court is based on the request that the accused persons are waiting for the information, and they've indicated that. The accused persons are still waiting for the judgment of this honorable court, and are still waiting for the record, the transcribed record of proceedings, which are aspects that must be attached to the application for direct access. So the fact that that application for direct access has not been lodged cannot be said, or this court cannot be invited to look at it as if the applicants are just raising issues and are not litigating those issues.
I don't know whether the parties seriously expect me to consider that. Yes. Because this is a bail pending trial, not bail pending. You may correct me if I'm wrong. Not a bail pending what is likely to be happening in the Constitutional Court. So should I really bother myself about the intended application for direct access?
I believe you should not bother yourself, my lord. The state was calling on you to bother and look into it, and I'm saying it's irrelevant. I agree. My lord, again, the state makes other irrelevant submissions which are inaccurate and not correct. The state submits that the accused persons received money. It forces us, my lord, to get into that venture where we look into the papers, the exhibits and the witnesses, and you would find that there is none that proves that any of the accused persons received that money. The money was paid to a third party, which is Black Deck Private Limited. The state has chosen...
You are simply saying that is an issue to be determined in the trial?
Yes. Yes, sir. My lord, I've dealt with section 169. I would not want to deal with it and the pages. Yes, my lord. I believe with that, my lord, those will be my submissions, unless if you wish me to clarify.
Very well, Mr. Maduku.
Thank you, my lord. I will certainly not repeat the points that have been made by my learned friend, Mr. Jeter, in response. I'll only just say a few things to assist the court further. First, in terms of the issue that the court has to deal with, we respectively submit that it is correct that you have to address the issue of whether or not in considering this application you treat it as a fresh, we use the word fresh application, to which you make no reference whatsoever to any proceedings that took place at the remand court or any such previous proceedings. Or you would want to say that this application must be one that is governed by the proviso to section 116 of the Criminal Procedural Evidence Act, which is described as a further application. That has to be determined, and it's also clear from the exchange with the court that the court is very clear that the applicants are saying this sort of application must be considered without regard to that. And we have used strong words like that the judgment of the magistrate court is irrelevant. But the only issue I wish to add there is that we have also placed before the court an alternative application. We have said that in the event that the court is not with us and that we would want the court to treat our applications as further applications on the basis that there is already indication of new facts that we have outlined in the application. We have said that as well. Now I wish to just add that in terms of the response by the state, one thing which has been unusual with respect is that my learned friend chose to read instead of addressing the court. It's a new development, but I'm sure he's entitled to do that. But in reading, he was reading through and through what then the court must note that that whole document is just a set of contradictions. That's our submission. It's just a set of contradictions. There's nothing with respect that is being said. We cannot tell from that document what the state is saying. On the one hand, the state says it has no obligation to make submissions in respect of compelling reasons because there is a finding on compelling reasons which is extant. That submission in one way suggests that they say yes, it's a fresh application, but our answer to your fresh application is that they are already compelling reasons. That's one way in which we may understand it. But there's also another way of understanding it, which is that, well, you are wrong. Your application is a wrong one because there's an extent. We are unable to tell what the state is saying, but at the end, it has not placed before the court any compelling reasons. Then they deal at length in the answer that is read out, which is now uploaded. More than half of that is on changing circumstances. We were unable to tell what they are saying, and we are honestly saying so with respect. It appears that they are saying there are no new facts, on the one hand. On the other hand, the document suggests that they are just teaching us on what changed circumstances are, because they quote cases on changed circumstances. So our submission is that there is no response by the state to this particular application, whether it is in the form of the fresh application or in the form of it being an application on changed circumstances. Then, in regarding section 169, that the court has raised on and on, we are clear, we have said it before. We now realize that what that section emphasizes is that when you appear before this court for trial, you lose your bail. If you had bail, you are placed in the same position as a person who had no bail. But we realize that persons without bail, my Lord, there is also a category of persons who may not have applied for bail. So so someone didn't apply for bail, so they would not be said to have been admitted because they never applied for it. Then someone applied and was denied, and another one applied and was granted. So those three categories, they are equalized in section 169. Once they are equalized, section 169 does not then preclude the making of an application for bail, which is what we say. And certainly section 169 must be read as in line with section 117A, and also I think in line with section 46 of the Constitution, 46 subsection 2 of the Constitution. My Lord, that section says that whenever you are interpreting any provision of any legislation which has an impact on fundamental rights, you must interpret it with a view to ensuring that you promote the spirit of the Bill of Rights. So if you look at
That's
section
146.
46, subsection
Or section 46 of the
Yes.
Constitution.
of the Constitution, it's a mandatory rule of interpretation. And so issues of bail are Bill of Rights issues given section 50. So whenever we interpret any provision of our criminal procedure, we must lean on the side of saying that the right to bail is not taken out. In other words, there is room for application. So it emphasizes the fact that the state would be very wrong in taking the attitude that it has taken. Then, just the last 2 points, I also wish to emphasize, my learned friend Mr. Zetro did that, but I'm emphasizing it, that the judgment of this court in HH 409 of 24 already answers the issues. In terms of that judgment, the respective position of the law is that these proceedings expire once a person has been committed to trial before the High Court. And that it will be a very new development if the High Court were to be asked to be bound, because what my learned friend has said, and I want to read a passage from their document. I have the document. It says that it will be on page, if the court may bear with me. It says, I think it's page 2. It is submitted that the judgment of the lower court, where the above findings were made, remain extant, in the sense that there was never any successful appeal against by a superior court. The suggestion, the position here is that you are bound. In fact, you must find that there are compelling reasons. And the reason for you making that finding is because there is a judgment of the magistrate court which says that you have no room to move. That's what they're saying. And that can't be correct, even on the reading that the Criminal Procedure and Evidence Act itself makes it clear that those proceedings expire. So on the submission we make, my Lord, it's clear that you have a very clear task. You have to decide whether this is an application as we are saying it is, and as we have put it before you, or whether the state can be correct that it is a further application. That's the decision. So we are starting on a crossroad. It's sometimes very difficult to start your journey on a crossroad. You have to decide which road you follow. And in this case, the court has to determine that. And fortunately, we are in court and we leave it in court to determine that. But once you determine in our favor, then bail will automatically arise, because there is no, the state has accepted, has not placed any compelling reason, it has refused to even entertain the idea that it might lose that argument. That is the point I wish to place on record. They have not, Mr. Mabaode has not accommodated that possibility. Instead, he brought this long document. But I thought that with all due respect, the state ought to have at least gone into the route of saying, in the event that they are wrong, but they think that they are correct through and through. So they must rise or fall on the basis of whether this court would treat this bail application as a first application. If you treat it as a first application, and you can, let's say you were to take into account, and we may be wrong that to take into account, you cannot do it in the absence of the state itself saying that is the case. What Mr. Jeter has already said, that they have not adopted, they are just saying we are bound by that judgment. That is clear. My final submission, my Lord, is what has just occurred to me when one looks at section 66. We find that there are two things there in section 66. A magistrate does two things. The first one is that they commit a person to trial in the High Court. Then a second separate thing is that they issue a warrant for further detention. That shows that these two are two separate juristic acts, because the assumption of the act is that the bail would have, in other words, the proceedings would have ended at the time that you have been committed to the High Court. You leave it to the High Court. And our reading is that you should allow us, my Lord, to keep saying that we think that that judgment 409 of 24 is correct, and that if the court were to do it would be a contradiction if we were to say that the bail proceedings have not expired. That would be our submission. Then there was a small problem. I had put some notes here that Mr. Mabaudi kept on wanting to read the heading of the statute. Section 7 of the Interpretation Act is very clear that headings are not part of the statute. And then Section 335 of the Constitution also repeats that headings are not. We must go to the statute itself. We must go to the provision. And I put that just for the guidance of the court. But those will be our submissions. We abide by what you said before. We think that we've placed everything before the court, and we pray that our clients be granted bail on the terms that we've put on paper in the draft order.
You have taken 2 days to argue this matter. How much time do you think I need to prepare a good judgment?
That's a typical.
You always assist me in making decisions. The rules? What did the rules say?
We should leave it to you, my lord. I think that we are in the hands of the court.
Well, I'm just trying to make the point that I really need time to consider judgments. Can I have your diary? Can I have your diary? I wanted to reserve judgment until the 17th, and then I realized that is the contested date. Anyway, I hope to be ready with the judgment in this matter on the 15th of January.
Indebted, my lord.
So judgment is reserved. Any other business, Registrar?
No further business.
The court will rise.
All right.
He's making very good point. But is now. You want to keep fighting.